Hello friends, please like, subscribe, share and comment. It will motivate us to carry on this project for the welfare of students preparing to get government job through shorthand. Thank you for watching. Ready, start. The controversy as to whether the plaintiff or the father of the defendant and his uncle are owners of the property in dispute is outside the jurisdiction of the judge small causes court. The possession of a tenant is the possession of his landlord, emphasis added. In my opinion, under the facts and circumstances of the present case, the provisions of Section 23 of the Act referred to above were fully attracted. Otherwise, also to avoid multiplicity of proceedings and to cut short the litigation, it was necessary either to return the plaint for presentation to a court of competent jurisdiction or to transfer the suit giving rise to the present petition to the court of civil judge Mohanlal Ganj, as the judge small causes court has no jurisdiction to decide the question of title. It is settled law that when in a suit in a small causes court, the question of title is raised, it is expedient for the court to return the plaint for presentation before a court competent to decide such a question. It is not necessary that plaintiff defendant should be rival claimants to the immovable property. The object of section 23 is to meet cases in which judge is satisfied that the question is so intricate that it should not be decided summarily and that it should return a plaint for presentation to a proper court. The object of the section is to enable the small cause court to decline to exercise its jurisdiction in small causes suit when the right of the plaintiff and the relief claimed by him depend upon the proof or disproof of a title to an immovable property or other title which the small causes court cannot finally determine, and to return the plaint to be presented to a court having jurisdiction to determine the title. In effect, the rights to or interests in immovable property are elaborately excluded, but as questions of this character may arise incidentally in small causes suit, a facultative provision is made by section 23 enabling the small causes court to send the matter to ordinary civil court but not obliging it to do so. A small causes court is expected to try suits of a comparatively simple character and therefore suits involving question of title should not be entertained by that court. Section 23 is intended to enable the courts of small causes to save their time by returning the plaints in suits which involve inquiry into the question of title. This section is designed to meet the cases in which judge small causes court is satisfied that the question of title raised is so intricate and difficult that it should not be decided summarily but in ordinary court in which evidence is recorded in full and the decision is open to appeal. The underlying principle under section 23 seems to be that where it is considered advisable by a small causes court that a final decision on a question of title which decision would if given by an original court ordinarily be subject to appeal and even to second appeal and which decision would ordinarily be res judicata between the parties should be given in the particular case before small causes court by an original court. The small causes court, though competent to decide incidentally the question of title in that particular case might exercise with discretion the power of returning the plaint to be presented to the original court, which would have jurisdiction to so decide on that title finally. Obviously, the section is designed to meet the cases in which the judge small causes court is satisfied. Stop. हेलो फ्रेंड्स, अगर आपको ये लगता है कि हमारी टीम के इस वर्क से आपका शॉर्ट हैंड स्किल इम्प्रूव हो रहा है और आपको अपने लक्ष्य पर पहुंचने में हेल्प मिल रही है, तो आप हमारे वीडियो को ज़रूर लाइक करें, सब्सक्राइब करें, अपने व्हाट्सएप व फेसबुक ग्रुप में शेयर करें, जिससे और लोग भी इसका लाभ उठा सकें। फाइनली, थैंक यू फॉर वॉचिंग।